Nice to have you all here. It looks like we attracted a lot of attention with this one. We have a lot of people registered. So welcome to Monday's monthly Q&A. Welcome, Felicia.
Yes, welcome, Debra. I'm happy to be back.
Great. It's hard to go ahead.
It's my pleasure to be here.
Wonderful. It's hard to believe it's already May 24th.
I know. Coming into the home stretch, right?
Yeah, there we go. Memorial weekend is just next weekend. So very good. Great. Well, what we wanted to focus on today is that really getting ready for the interactive process. It's been a busy couple of months with lots of IPMs for a lot of different reasons, not just our usual work-related injuries, but with other medical conditions that may or may not be impacted by COVID. And then, of course, those underlying conditions impacted by COVID that have led to requests for accommodations that might be beyond the usual. And so because of some challenges that we have had in some interactive process meetings, Felicia and I quickly started talking a couple of weeks ago about, what could people do or what do people face, but then what could people do to be better prepared? And so there are a few key things that we've got going on here today that we want to share with you. And so with that, Felicia and I have had the opportunity to not only present, on these monthly Q&A and address your questions, but we also presented at the JPA spring meeting back in April, as well as for Macro Pro, which happened to be statewide. So we've been working closely together for quite a while now. And so these are sort of, I think we can all agree, it's been one heck of a roller coaster. For the last 2020, and here we thought it would be done in 2021, and now we're May, and we're still, we see the light at the end of the tunnel, but we're not quite there. In fact, I just saw some guidance today from the EEOC put out by SHRM, the Society of Human Resource Management, about what employers can and cannot ask about getting a COVID vaccination and wearing masks. So that's another topic. But are you ready for your next IPM? We hope to share some tips and tricks as far as what you can do to be involved, and who needs to be involved, and what information should be prepared, and how can you prevent things from going south on you. I sort of called Felicia up in a little bit of a panic a couple of weeks ago. I said, oh my gosh, this is not going to go well. I can see the writing on the wall. And it was about the civil side, not the workers' comp side. And so that's what got us going in taking a look at what we're doing. And so you saw this in the invitation for the program today. I tend to do a lot of research to try to keep on top of what's happening at both the state and federal levels. And so I found it interesting, but not surprising, that California is at the top of ADA complaints. Florida and Texas and New York were the other ones. And those four states do tend to be sort of the leaders when it comes to employment law issues. And while the civil complaints have fallen down under various forms of discrimination, the cases under the ADA have actually increased threefold. That's a lot. And then, of course, in California, we are always the leaders, aren't we? We have a couple of additional laws that actually add to the monetary damages that already exist under the ADA. And so handling things outside of the, well, let me clarify. Even if your employee has a work-related condition, we cannot rely totally on workers' comp. Would you agree, Felicia?
Yes, I think there's a misconception that the claims examiners and the TPA are really the experts on this, and they're not. They really just have the notes and the work restrictions, and the experts in the ADA and the IPM world are obviously yourself as our consultant, and on our civil side, interestingly enough.
Yes, so it can get to be very complex. And I know for both Felicia and I, she particularly is, well, we both have extensive backgrounds in workers' comp, but around 1990 with the ADA passage, I got very heavily involved in the ADA, and so have practiced actively in that area. And so it's years of amassing experience and exposure. And so with that, we would like to have you answer a few questions. So we have some polling questions to present to you. And so this is where you have an opportunity to put in your response and we'll see the immediate results. I wanted to get a feel for where are you with some of these key elements that can get us into trouble when it comes to the ADA side of things, not workers' comp. So your first question, does your return to work program include a time frame for how long temporary modified duty is available? So let's take you to the first question. Okay, great. We have 83% of you who do have timeframes for how long temporary modified duty is available. And for a few of you, you're not sure. And so this is something that you want to take a look in terms of your own district policies, because like so many things vary district by district, right, Felicia?
Yes, some have shorter term and some have longer terms, but based on what they bargained with their unions.
Yes, and thank you for adding that, because I think a lot of people are not aware that this is something actually bargained with the labor unions then. Okay. See here. Did I share the results? Yes, I did. There we go. Okay. So next, if yes, which for 83% of you said yes, do you follow a 60 plus 60 day model or a 90 plus 90 day model, or does it go on indefinitely until MMI? So we'll put that question back out to you again. Oops.
And Deborah, you may say what MMI is just in case.
I'll let you do that while I try to get the poll back up.
So MMI is maximum medical improvement or permanent and stationary. They're synonymous. They mean the same. They mean the same thing. It's when the doctor releases them from care with permanent disability and permanent work restrictions.
And here are the results. Again, most of the school districts, and we find this in general, right, Felicia? Most schools do follow a 60 by 60. And then for some of you are not sure. One of the challenges I should share with people that got Felicia and I commenting about or working on this together is that we had the situation of where an employee had been accommodated through temporary modified employment for a very extensive period of time. And it went well beyond the 90 plus 90. And then of course, COVID has been a whole nother year in many respects. The COVID conditions have allowed for more flexible accommodations because of the new needs and demands required in the workplace. But now as we're wrapping up the school year and COVID is starting to hopefully come to a close, then bringing some of those temporary accommodations to close became very important. What's been your experience with that, Felicia?
Well, I have to say what we experienced throughout COVID was in general with workers' comp injuries anyway, the disability time typically that they're on temporary modified work restrictions would be 6 to 12 months. That would be an average unless you have an employee who's having multiple surgeries or what we call failed surgeries, where they're not doing well and they're having complications and they have to go back in. During COVID, all treatment was delayed and all surgeries were delayed. So that 6 to 12 months got stretched out. And so I think the case that we were talking about where they were on temporary modified duty, I think it was a year and a half or longer, right, Deborah?
Yes.
And that created an expectation. That's why we don't recommend that you temporarily accommodate until they're MMI, because that certainly creates an expectation that you can accommodate forever because you have been for such a long time. Kind of sets you up for failure if you're going to say at the IPM that you can't accommodate on a permanent basis, but you have been for a very long time. Makes it difficult, more difficult to defend.
Yes, and that defense piece of it is huge because you are setting up an expectation, and EEOC, Equal Employment Opportunity Commission, that oversees the ADA, has long said, that, and it's really part of best practices in disability management, that to avoid going beyond 6 months on a temporary accommodation. We talk about, well, 90 days is, it's not easy for an employer, but it's doable. We can usually live with something for 3 months. But then if the person is showing improvement, but needs more time to recover, then it's appropriate to continue, consider an extension of that time, provided it's still fitting within business needs. And then there was even another ruling more recently, I believe it was in the spring of 2019. And people can learn more about this by going to my podcast and listening to Mark Ponce about this from Albertsons, as well as, I'm blanking on his name all of a sudden. I'll put that into the chat box before we finish. But where they said, if somebody has been off of work, and in this case, the company actually had a policy of if anyone's off of work for 1 year, then their employment ends. And in this particular case that went to trial is that the employee did provide medical documentation before her 1 year to say that she needed another 30 days to recover, and that her medical provider did expect that she would be recovered enough to come back to work. The company said no, and they got sued. And so the EEOC has gone on to say that, again, if you have defined a discrete period of time for which an additional extension is needed, that's permissible. It cannot be indefinite, it cannot be uncertain, it cannot be going on forever. We had another situation where an employee requested continued work from home until masks were no longer required in the workplace.
Mm-hmm.
Well, we have no control over that. That is totally indefinite. And even now, we don't know, now they're saying, well, you don't have to if you have a vaccination. Well, then there's some limitations about asking about the vaccination, So, and she pushed back when I did ask about the vaccination. I said, well, but this is an area where we could accommodate, and so it was a very challenging situation. So again, if it's defined, discrete, short-term, in like another 30 or 60 days, 90 might be stretching it a little too far if in that kind of situation. So the EEOC has been very clear on this for a very long time and have even more recent court cases to uphold that. So be mindful of your practices there. And then the next one I want to ask, because it sort of ties into what we were just talking about. If yes to number 2, do you allow temporary modified duty to continue after the first 60 or 90, depending upon your policy, if there is no change in functional limitations? This is a very important one, I think. So here's our next polling question. And so again, let's see your responses. I'd like to see what you're doing around this.
You're right. I see differences, Deborah, in the way some of the districts handle this. Some, if there's no improvement in the first 60 days, they send them home. If they're improving and there's changes in the work restrictions and it's dynamic and it's flowing, then they'll extend. So they kind of have a meeting after the 60 or after the 90. But some just go right all the way through to 120 or 180 without any discussion or parameters on that. So that really varies district to district from what I've seen anyway.
I would agree, based on my work with the school districts over the last several years. A wide variation in practice on that one. And we'll go ahead and talk more about that then in a moment. So I'm going to end the polling. And interesting. It got a lot of, it depends. We didn't get very many responses, but it depends. So I'm actually
it's case specific, and that is a lot of what I see.
Okay. And so what is your experience, Felicia, in terms of best practices? You've worked many years with the school districts in your role at the JPA, and what would you suggest people to consider doing?
So the best practices, obviously you have some ideas when an IPM has red flags. 2 or 3 union reps are going to be in the IPM. That's a red flag. You have problems. There are 2 or 3 different notes from the work comp claims examiner that have different work restrictions. That's a red flag that there might be some problems. There are multiple doctors treating a person for multiple injuries. Also, complicated case may cause some difficulty at the IPM. Definitely, if the employee says that they might have either their work comp attorney or they might go to the union and have a civil attorney attending the meeting, we want you to balance the table. You usually know when there are going to be some challenges ahead of time, so you want to put more time into that. And on those cases, we definitely recommend that you have a mediator. Third-party mediator is always good if you know that you're running into these type of challenges that we see. If you just go ahead and you're not prepared for an IPM like that, things can go south on you really quickly.
Yes, I would agree, and not just because I play that role of mediator, but the value of having a third party is it allows you to preserve your employee-employer relationship without damaging it by having to draw the line or be the bearer of bad news and things like that. And so that's really let me do that hard work because I'm not invested in the employer-employee relationship like you are, and that's. I think from my perspective, having been a mediator in this line of work for so many years, that good faith, compassionate kind of approach early on can do a long way in mitigating the potential for any kind of civil action.
Right. And because the litigation is civil, it's failure to accommodate, it's failure to meet, failure to interact, it's wrongful termination, right? Having them run out of leave, go home, and go on 39-month. This is all civil litigation. So a best practice that I do recommend a lot that a very few districts do is talking with your liability examiner before the meeting to talk about some of the pitfalls that you might run into, especially if you think that it's going to litigate on the employment side, if you have to make a decision that you cannot accommodate, because the districts do make the decision in final, not the mediator, of course, not the work comp side. The district always makes the decision from an HR perspective and bears the responsibility, right, of that decision, whether it litigates or not. And we have seen some litigating now, and I think that led to our having this conversation today, right?
Right. I'll add to that too, Felicia. Well, obviously we know 2020 was sort of a wash, and we pivoted very quickly to the Zoom platform so we could, keep meeting the people's needs. But in 2019, I saw quite a few situations of where the failure to engage in the interactive process. There were a couple of attorneys, employment law attorneys, that were actively looking for those cases, and because that also is a compensable charge to the employee. And so very, very important. I've done some pretty extensive, chronological histories for a few school districts to demonstrate how far back accommodation processes have gone on. Now, one of the things before we get into this list, and thank you to Felicia for crafting all of these questions, I just do want to emphasize, for those of you who may have taken my the trilogy workshop series when we were still live, I haven't gotten it into webinar yet, but we did talk about, in terms of best practices, you really do want to pay attention at that first 60 days of temporary leave, and that is really an excellent time, whether it's informal among all of you, or if you bring me in, to have a meeting with the employee, so that you can lay the groundwork as to how this process works, the timelines involved, and the steps that are to be taken in terms of the temporary process, as well as the use of sick leave and the 100 days of differential, or if it's 5 months and then the 39-month rehire, because a lot of employees just don't know this. And that's what happened with this case from a couple of weeks ago. That conversation had never been had, and so she was absolutely dumbfounded when the district concluded the meeting by saying that we can't accommodate, you're going home today. And she had absolutely no idea, after being temporarily accommodated doing a portion of her job throughout this entire period of time, and she was working because it was nutrition services, and so they didn't stop really working, and so it was really a blow to her, and of course led to a lot of flurry afterwards, right, Felicia?
Yes, she's going to litigate probably. And also there was a lot of conversations with the district and the work comp staff, and they have nothing to do with the return to work IPM process or the litigation. So the discussions need to be had with your JPA civil attorneys or your advisory council, because this is employment law. This is not workers' comp, but workers' comp does provide you, they don't provide you with the reports because those are medically confidential. They provide you with a cut and paste of the permanent work restrictions and the temporary work restrictions when you have them. So those permanent work restrictions, I always tell the districts, those are on fire. You have to look at when you get an email with their PNS or MMI, and here's the permanent work restrictions. You need to be starting to think, we need to schedule a meeting. You need to be reaching out. Do we need a mediator? Then you start looking down this checklist. And do we need to have a pre-meeting? Do we think we're going to have a problem? And if the employee says they're going to bring an attorney, do we need to balance the table? Do we need to have either the JPA legal panel on the work comp side if they bring their comp attorney? If they're bringing an employment attorney, do we need to contact the JPA civil side to pay someone to come and assist us? On the work comp side, it's going to be paid for off the work comp file.
Yeah, thank you for emphasizing that. Is that, yeah, if it is a work-related injury, it is paid for through Athens, and we coordinate very closely then. And it's interesting, I have had a number of IPMs of late, you know, the virtual kind, of where we have had attorneys involved, and quite often they are there more to simply observe. I just did one for another public agency last week where I actually did ask the attorneys to weigh in because you know, it was a complicated case, different medical guidelines from the AME to the PTP and so on. And the employee wasn't sure at all what he could do in his recovery. He was going through another surgery. And we ultimately said, you know, let's just defer this process. We had to do it for the workers' comp timelines on the AME report and the PTP. But with the additional surgery coming up, which could change everything again, we just said, let's just defer it. Everybody was in agreement. The employee was happy. He's going to have his workers' comp benefits while off on his work-related surgery. And but I was really thankful to have both attorneys involved. But oftentimes they'll say, well, we're just going to sit here and observe. We're going to let the employer and the employee, you know, have their conversation. But it is helpful. It sort of gives a comfort level on those more complicated matters. Yeah.
Yes.
So Felicia, I'd like you to really address, we have 2 slides that we'll be showing you. And after this situation, she was great in generating questions. So maybe you can talk a little bit more. You have touched on some of these things already.
Well, I think one of the things that gets missed, and we have one district that, and Debra, you might address this a little bit later on, but she just does a wonderful pre-meeting summary, and it includes what's going on the employer side. It's usually when Dr. Dupree is going to be mediating, and it includes all the notes and the work restrictions, and then if HR has any comments or any other notes, and she does this sort of pre-meeting summary, which to get ready for the IPM that I think is good, and then she prepares where they are with their leaves and their time off and their benefits, and is an unpaid leave something that could be offered to the employee versus a 39-month rehire? Does your district do that? Does that need to be board approved? So usually you've got to have HR and leave information available. Some of the IPMs that I'm asked to attend, the district tells the employee, you know, at the end of the conversation with Dr. Dupree doing the mediation, that their decision after reviewing everything is they're not going to be able to accommodate, and they're going to go home. And that's it. There's no conversation about PERS or STIRS or this is where you are with your 100 days. This is how much time you have. You're going to be on the books until this date. You have the availability. You're out of sick leave in a week. This is your choices now. You can ask for catastrophic leave. Someone should be there to address all of those things, whether that's the work comp rep that's there or that's HR function that's there. And also, I think you should be ready, obviously, with all the positions that might be available, not just the one that they're in. So there's quite a bit of preparation that needs to go in before an IPM if you want it to be successful and not go south, because it's emotional, especially if the person is not going to be able to be accommodated.
Absolutely. And so I did put up on our screen, you know, just sort of slowly scrolling through. This is a kind of overview. One particular school district, I've got a couple other public agencies who do a great job on this, and they did it for the complicated one I just talked about last week. And so by getting this a day or two ahead of time, it allows me to sort of organize and sort through and get the chronology down in my own head so that I'm better prepared to facilitate through these details. And again, by having someone like myself as a third party, then it takes the burden off of you as the employer representative to put out this information. And I try to be very transparent and let the employee know in order to be prepared for this. I do request certain information. So I do have some background as far as your condition, but I will need to ask some clarifying questions. That way I'm prepared with the kind of clarifying questions that I need to get a handle on and better facilitate the process. And in this particular case, it's really helped me is that this particular employee had actually been released to full duty back in the fall of 2019, only to exacerbate his condition and require further surgery. And so he was returned to modified duty at one point, but with accommodation. So we were able to go through. So this is another thing, is that just because you've provided accommodations one time doesn't mean that you keep providing them if they're not needed. And so I had an employee, again, another difficult one, long history, who said, well, I had an ergo evaluation back in 2015. I want the same stuff. It was like, that was at an entirely different location. The technology and what you're doing is very different. And so we really need an assessment of your current work situation and to identify current technology. And so after I explained that, she goes, oh, okay. And I said, we're not going to just duplicate what was done 6 years ago because, it may or may not be needed. And so in this case, we were able to verify what was provided, what wasn't provided, what was still needed, et cetera. And so, so the good news, folks, is that we do have, I gotta change my sharing again here, is that we do have, I'm sorry, where is it?
I did want to add one thing too. A lot of times when the claims examiner sends a permanent work restriction, they will send what we call in workers' comp highest and best. Because in work comp, there's different hierarchy than, as we've talked about, than there is in the ADA and IPMs. So they'll provide the agreed medical examiner's permanent work restrictions, which they consider what the case is going to be resolved and settled on, or the qualified medical examiner's work restrictions, which they also consider what the case is going to be resolved on. But frequently what happens is there are other doctors. Sometimes there's one or two or three. Sometimes there's a psychiatrist involved that also has permanent work restrictions. There is other orthopedic consultants that have work restrictions or comments about return to work. And then there's a primary treater that sees the employee on a regular basis, not these what we call med-legal examinations. And the last IPM and the last couple that I've been involved with where they really went south, Dr. Dupree was used as a mediator, but was not given all the notes. But the claims examiner gave the note that they felt was the most important, right, in their world. But you have to clarify, is this all the notes? I need all of the notes from all the doctors so we can lay them all out on the table and consider all of them. And then you also need to go to HR and find out, are there any notes I'm missing? Are there any notes in any other conditions, a diabetic condition, any other thing? We did an IPM for one district, and this employee not only had the work comp claim with restrictions, but also had a non-industrial condition going on that had some temperature restrictions that we didn't even know about. They came up in the meeting, and then we were sort of all looking at each other. So you need to check with HR to make sure that there are no other notes available, because all notes have to be considered when you're doing this process.
Yeah, and that's, thank you for bringing that up, because in this one I was talking about last week is that, because we had such a variation and the employee was sort of caught in between what he felt he could and could not do, gave me the opportunity of saying, well, the AME's findings will be used to resolve your workers' compensation case. And so that's over here, and you're not there yet. But for our return to work purposes, we have to take into consideration all of these things. And so I was able to clarify for the employee as well as the employer then where we were. So what I just put up on the screen here was another 8 questions or 7 questions, I guess, that Felicia came up with. And she's talked about some of these things too. And so one thing I really want to emphasize is that going down to number 15 is making sure that you have knowledge and preferably an actual list of job openings, because that's a critical piece of the ADA or interactive process. And so either, providing your website link, making sure you have a clear list of what they are, because that's important information to take a look at. And this is where I try to tie in then, if in fact they cannot continue with their usual job because no accommodations are available, then how they can use the supplemental job displacement voucher to acquire training that then they could look at, what's necessary for alternative positions that then they could use in the 39-month rehire list. And so I hope that you can see how valuable an early IPM can serve you by educating your employees about this entire process, because I often have to say sometimes this is a one-stop deal, and sometimes we have to come back periodically. And for a couple of years, I know there were some cases we had to come back on an annual basis because the changing student population, in what the employees' functional limitations were. Sometimes accommodations could be made depending upon the students in the classroom, whether they were high risk for behavioral challenges, et cetera, like that. And so, Felicia, any more comments or words about these last 7 before?
Yeah, I wanted to add that I'm happy to come in on IPMs that are complicated. All the ones that I get asked to attend, typically, I think the district has an idea that the work restrictions they're not going to be able to accommodate, and the employee is going to be going off work. And typically that happens the day of the meeting, right, Deborah? And the employee is usually shocked. And that's when it hasn't gone right, because they shouldn't be shocked. But usually that's when I'm there, that's what happens. And I'm happy to come in. I do not, if they're represented, I can still come in, but I'm just speaking to, because it's important to remember, if they're going to be going home that day because you're not going to be able to accommodate, and then they're running through leave and someone's there to talk about the leave they're running through, sick leave, and maybe they're on 100 days of half pay, so they're having financial duress, we can help, because if they're MMI or permanent and stationary and they have rateable permanent disability and you ask me to come, we won't be talking about settlement there, but we'll talk about permanent disability advances, because we can start advancing if they're no longer working. We don't pay PD advances when employees are working for the district on temporary accommodated duty, but we do provide PD advances, which are advances against the settlement discussion we're going to have down the road. And I can speak to that because that can help sometimes with the financial pressures that are brought to bear that cause employees to start crying and the union to start getting really upset and threaten litigation, right, when these decisions. So again, that's just an offer that I make. I'm happy to be included. I'm happy to help. I stay quiet most of the process until we have issues that come up on the comp side. And sometimes the comp claim is very complex. And so I will have a good idea of what's going on with all the multiple body parts and injuries. So.
Thank you, Felicia. Yeah. And I want to just emphasize too that forgot to take the subtitles off there. That my process, this is something contracted through the county office or the JPA. Same pricing is available to you, but it does come with a pre-IPM opportunity. And so you can easily schedule that ahead of the IPM or even a couple of days ahead of the IPM. Again, that helps me understand some of the issues. I did want to share this with you before we open it up for Q&A. I have developed some flowcharts to better amplify the process. And this is part of the guidebook that I started in 2019 and then I was ready to publish in 2020 when COVID hit. And so I kept trying to come back to it, but everything kept changing as far as COVID guidelines. And I just said, you know what, I think I'm going to wait till this sort of settles down and we sort of see where our future is going. So for those of you who have pre-purchased, again, thank you for your patience, but it's one heck of a year,
Mm-hmm.
So all this stuff is part of my manual that will be coming out. And then this also what happens at the IPM process. I do have a little video and an overview of some tips for participating on Zoom and the structure of the meeting so that employees have some idea of how this is going to go up in front of time. And then also we talk about the alternatives. And so that's something to be aware of that's forthcoming. So let me
And I think, Deborah, too, I wanted to add, sometimes at the meeting, this isn't ideal, but you don't have a decision maker at the meeting. It is okay. It's not ideal, but it is okay to say we don't have a decision maker at the meeting. The district needs to regroup and talk about the decision, and then we'll report that out. That's not really ideal. The ideal should be that the decision maker is at the meeting and you were prepared at the meeting to either say, yes, we can accommodate, or yes, we can offer these alternative positions, or no, we cannot. And we're going to be talking to you about leave and STRS and PERS benefits and workers' comp benefits that may be available to assist you. You're going to shift the conversation over to how we're going to help you after you go home. So sometimes the district isn't prepared, and then the meeting goes south, but there isn't the proper people there. There isn't HR there to talk about leaves. There isn't anybody there to talk about other positions. There isn't a whole checklist on what's going on in their duties. You want to make sure that you have the right people in the room.
Yep, absolutely. Yeah. So I want to let everyone know, and we'll be opening up for Q&A, is that we have prepared these 3 documents. We did put what you just saw on those 2 slides, those 15 elements, into a checklist. Then we also have that sample medical employee medical history, so you get an idea of the kind of information that can be helpful. And then I created a template from that you can use to in a Word document that you can use for your own purposes. And so I'll have all of that available to you if you complete a 3-minute survey for us, so that we have some idea of how we're doing here. And that would help us get because we've been at this now, Felicia, for about 15 months now, I think.
Well, there's been such a big increase in IPMs because of COVID, not only because of the mask wearing, and then because of the vaccines, and then because of underlying health conditions, and then because of families with children not going to school, which we all know about that. And, there were so many things that we got hit with at once. A lot of HR groups really got inundated with requests for non-industrial IPMs, as well as the work comp IPMs that were going on. I did want to add that if you have a psych stress claim on the comp side, I really suggest that you do have a mediator, just because Dr. Dupree, that's her background as a licensed clinical psychologist. And these psych claims or even if it's a medical injury with a psych component where they're getting psych treatment on the comp file, you really need, I think, the professional help. They can really go sideways very quickly.
Yeah, they are delicate. And again, this
very
sensitive and very challenging. People have struggled a lot in this last year. And so very important in that. I went ahead and put the survey link into your chat box. So all I have to do is click on it and it'll take you right to the survey. So very quick and easy. And so do want to open it up if you have questions. Sort of lessons learned from the COVID-19 pandemic and where we are. And it's been a complex world. And so what are you burning to know more of in our last few minutes? Anything? Go ahead.
I wanted to add too that many of you are on the risk management side because that's where work comp reports to. And then many of you are on the business service side because that's where work comp reports up to. So the district's kind of split it out where it reports up to. It's really important that if you're in the business services side, that you and HR, you have to work like this. Risk management and HR overlap in so many ways. The IPM and the ADA is really kind of like, lives more in the HR function. So risk and HR really have to work together on these things because risk has all the information on the work comp claim and HR has all the information on benefits and jobs and all the other things. So a lot of the districts have both there. They have the risk manager there and the HR person there ready to make a decision. And I think that's, if I had to say best practices, I think that's the way to do it with the ones that are comp injuries anyway.
Yes, yes. Well, I didn't see any questions in the chat box, and I don't see anybody unmuting themselves or raising their hand. So any last words, Felicia?
I just wanted to say it's a really, I think you have to be careful how you step when you're here, and it's better to ask a lot of questions and get help, not only from on my end on the comp side, but also from Lisa and Brandy on the liability side, if you're a member of the JPA, and reach out to civil too, if you think you're going to have a problem before you walk into something that you can't walk back out of.
Absolutely, absolutely. And I will just let everyone know we will have another Q&A session for June, but we will be going dark in July. And so then we'll pick back up and we're scheduled all the way through June of 2022. It sounds so far away, but it'll come fast.
School will start again before we know it, right? The time has been speeding by. So yeah, for me.
Absolutely. Absolutely. Well, I want to say thank you to everyone who's participated here today. Again, we'll be doing some rendering to our video and PowerPoint and getting that off to you. And so look for further follow-up from us within midweek or so. Well, thank you very much, everyone, for being here. See you soon. Happy Memorial Weekend.
Yeah.
Bye-bye.